Wonderful. Nice to have you all back. Davidov Podcast, Davidov Wealth Podcast. And along with my co-host, Ethan Davidov, we've got a special guest today, Audrey Bernhardt.
Hi.
And Audrey is an attorney. Why don't you tell us a little bit about your practice and what kind of work you do?
I do mostly trusts and estate administration and guardianship and a little bit of estate planning.
Wonderful, wonderful. So we'll dive in today on one of those subjects that you talked about, one of your areas of expertise. We'll talk about guardianships. Can you take us maybe through what is a guardianship to begin with?
Actually, in New York State, there are 3 kinds of guardianships,
Okay.
but I think you want to know about the one that's called an Article 81 guardianship, and it deals with adults who don't have capacity.
Okay.
And a guardian would be appointed to address the financial and medical needs of that person who's unable to do it for themselves.
So what's the process of getting somebody appointed as a guardian, and when do people typically find out, hey, I really need to go through this proceeding?
Usually the person who realizes it is not the person who needs the guardian.
Yeah.
Okay. So that person, and you say that because that person is either incapacitated in some form or having difficulty with memory, dementia, or things of that nature.
Correct.
Okay. And where does that typically happen? Like who's coming out and saying, Audrey, we're going to need some help with this issue?
Usually it's a family member
Okay.
who realizes that their parent or an older family member needs some help. And sometimes we've had a situation where somebody came in to discuss some planning, and it became apparent to us that the person who was supposed to be doing the planning didn't have the capacity to do that, and
Right.
a guardianship was required.
Right. Well, and when you say planning, so they came to create a will or trust or do some sort of estate planning to create
Correct.
some legal documents. And when you're interviewing this client, you're finding out maybe they don't have the requisite capacity that they need. So you have to be able to understand things and able to understand and to delegate that responsibility to you to draft their estate planning documents,
Correct.
right? And so you felt that person wasn't able to do that.
Yes, it was pretty.
It was evident. Okay.
Yes, it wasn't a nice thing to have to tell the family member that brought the older person in
Yeah.
that we couldn't do estate planning, that
Okay.
we recommended a guardianship.
Okay. And so what does the guardianship part of it solve for that family or for that person?
It appoints somebody else to make decisions for them.
Okay.
But
Why would I need somebody else to decide anything for me? Why would I need a guardian? Hopefully I won't. But in the event that I do, why would I need somebody? Does that happen when I don't have something in place?
absolutely. With this kind of guardianship, there are 2 kinds of aspects to it. There's the guardian of the person,
Right.
and the guardianship of the property. And to be a guardian of somebody's personal needs means you make their medical decisions and make sure they go to see the doctor and whatever. And the other kind, the guardian of the property, makes financial decisions. So if somebody has an individual bank account that's only in their name, they're the only person who can access that bank account. But if someone is appointed as their guardian, they would have access to that bank account. But both of those things can be avoided with a power of attorney and a healthcare proxy.
So to the audience that may be saying, well, all of my accounts are actually jointly held with my spouse or with my kids. What do you say to somebody like that who says, I probably don't need a guardian because I'll never have somebody? Is there a type of account like an IRA or retirement account that's not joint that they may not be considering and that may need to be handled, and there's not somebody on that account? And so it's important to have
absolutely.
It's important to have that power of attorney allows that person to act for them. And of course, when you're planning ahead of time and the power of attorney is the tool that we can later use to help with when if the person becomes unable to do things on their own. The attorney can help guide the family and help them in saying, okay, the power of attorney could be used to maneuver assets from here to there, and we can qualify for benefits and
Let's
other
just
things
take
like.
a quick step back. Do you mind going in and explaining what a power of attorney is?
Absolutely. So I call it the key to doing things if you become incapacitated when it comes to financial things. So imagine that mom is getting older and she had a hospital stay, and they took the Medicare information. Everything was there when she went in, but you get a bill and it's like $15,000. And you say, how can I help mom get this reduced? You call the insurance company and they say, well, who are you? And so, I'm someone's son. I'd like to help my mom deal with this issue. Well, that in itself doesn't permit us to do those things. So we need to have the legal authority to act for mom to be able to do that if she's unable to handle that herself. And as we have aging parents, or loved ones, we're certainly going to run into those kinds of issues with them where they're not necessarily going to be able to handle every aspect of growing older with they may need somebody else to help them with things.
Something I'm seeing a lot right now being discussed online is the DIY power of attorneys.
What do you mean?
They the types of power of attorney forms that you can just download off of some kind of site.
Yeah.
Will those types of forms be able to help avoid guardianship, or?
Sometimes, but sometimes they won't. For example, in our practice, when we're writing them, we're including all kinds of provisions that really allow us to do all kinds of elder law planning to be able to qualify somebody for benefits and so on. Typically, those documents are just sort of giving you the writing authority to be able to pay the bills and so on. But that may not be all that you need.
So it really is important to come in, speak with a qualified attorney who is focused in the area rather than trying to do it yourself.
Absolutely. Elder law attorney, estate planning attorney is going to be able to draft something that's going to be tailored for them and will have the kind of provisions that would allow for us to do things. It's like having the right kind of tool for the right time.
Yeah. Unfortunately, the forms that are online aren't always state specific, or people don't really know what it is that they're signing, so they don't know how to fill it out. So it lacks giving them the authority that they need, whereas the durable power of attorney that we have really has a broad spectrum of powers, even to the point where if somebody has done a revocable trust, joint revocable trust, and one of the members is later incapacitated, their agent can sign for an amendment for them.
Right.
Wow.
Yeah. Actually, you brought up before, you asked the question of when do people come to you and who is it that comes to you? And you mentioned that it was the family. And I recall when I went through law school with the Elder Law Clinic, one of the clients that we had there was somebody who was elderly, living in Stuyvesant Town in the city. And as part of our clinic, we became the court evaluator for them. We'll talk about that in a minute. But the case was brought by the nursing home, and oftentimes it's either adult protective services or it's a nursing home where the person is there in a nursing facility, and now the nursing home wants to get paid, but they can't get paid because there's no appointed agent for that person, and the person doesn't have the ability to do that on their own. So sometimes we think it's the best, it's the people that are around us, the family members, that are going to petition for guardianship, but it's not always the case. It could be a nursing home.
Right.
It could be, and there are firms that basically do guardianships for nursing homes. That's their practice area. Taking it back to what happened. So client comes to you and says, "Mom needs a guardian." or we need to do, they usually don't say I need a guardian, they say we need to do X, Y, Z, and we're not able to do that
Right.
because mom doesn't have the ability to understand how to execute these documents or doesn't have the capacity. And so you recommend a guardianship at that point, and that would be the last resort. But what happens in that situation? Can you walk us through mechanically what is it that you need to gather? What's the process of going through a guardianship and what happens through that?
Well, as far as the information that you get, you need the potential the person who's going to get the guardianship is called a ward. You need their information. You need all of their family information. Any interested parties, which might be friends or neighbors. And you need financial information. If they don't have a power of attorney, you're going to need to know all of their all their assets.
Yeah.
And so you would gather all that and put in papers to the court, and you have to notify all those people who are interested parties.
Okay. When you say notify, you mean serve them.
Yes.
Which is an added expense, and so you've got some kids, you've got friends and other people that are deemed important to indicate on there. So each one of those people has to get served. Who pays for that?
Well, the client.
Okay.
And this
Always
is
the client.
Yeah. This is an expensive endeavor because not only does the client have to pay our fee, which is a minimum of $7,500.
Okay.
But then there are other people who are usually attorneys who are appointed by the court. That would be the court evaluator, who is the eyes and ears of the judge.
You mean the judge can't go out and do an investigation and see if the person, in essence, what you're doing is the petitioner, that child or the nursing home in some cases, is alleging that somebody doesn't have the capacity to do certain things. They can't make medical decisions. They can't sign their checks. They don't understand. So they need to appoint somebody else to handle things for them. And there's going to be a hearing in court. But before there's a hearing, the court will appoint, as you said, their eyes and ears, and they'll appoint an attorney or somebody else who's qualified to do this work, who will go out and essentially do an investigation and then provide a detailed report to the court, typically, over 20 pages, I would say.
Yeah.
And would make a recommendation to the court whether this person does need some help, whether the kind of help that's been requested on there is the appropriate level of help. And then along with that, they'll give an affirmation of legal services or affirmation of services and say, hey, I've worked, this many hours on this case. They plot out all the hours and they ask the court to pay their bill. Where does that money come from?
The client.
Okay. So actually it gets ultimately it gets reimbursed back from the person who is deemed to be incapacitated.
Right. But also
If successful.
If successful.
Yes.
But
If
also
successful.
the court evaluator has to meet with the family members.
Right.
And other interested parties sometimes. So that just adds on to the bill.
And if there's any kind of familial disagreements as to who should be in control, that can really increase the process length and cost.
Yeah, you may have two siblings that fighting out over who's going to be the person that's going to be in charge of mom or dad's finances. One child says, I want to be the one because I live with mom. Another child is saying, well, you live with mom because you don't have a steady income and you don't meet the qualifications. And so sometimes you can see a lot of resentment between them and a lot of contention.
And mistrust.
Mistrust for sure, yeah. And so how long does this process normally take?
It takes several months. Initially, when you submit papers to the court, there's a hearing within 28 days. But after that, it takes a while to get the order and judgment. I'm waiting for one now.
Okay.
We had a hearing in February, and
So we're now at the end of April,
Yes.
and so it's been at least a couple months.
yes, and
Wow.
I called the court, and in fact, just today I was told
Give them a nudge.
she's going to sign. It's with her now. So
Okay.
and because I thought I missed something, but yeah, but the court does not like giving guardianships. They don't want to take away somebody's rights.
And so specifically, if you're asking for too many things, they want to make it very narrowly tailored. But there's this problem of needing, life goes on. People have bills. You've got to pay the bills. They may have a maintenance bill. They have a tax bill. All of these things. In the interim, somebody either has to continue to pay them out of their pocket and get reimbursed later if they can afford to do that.
Also, sometimes there's a temporary guardian if there's a bump in the road, if the family can't agree as to who would be appointed, and then it might be somebody who isn't a family member, and that person may have to be paid for their services.
That's true, and guardianships are sometimes used as protective measures to protect that particular individual and the community. Going back to the case from law school, I remember that case was brought about by a management company. This woman she was in her 80s. She lived alone. She hadn't paid her bills because she became forgetful and just had some health issues. And the case went to court for housing court. And through there, they said, well, this person didn't even show up. They're elderly. And so they appointed adult protective. So they appointed a caseworker who then made a recommendation for adult protective services. They come in, they try to see the patient or this individual, and they find out that the individual lives in a 2-bedroom apartment she's been in for the last 50 years. She pays a very low amount. Landlord would certainly love to have her out of there and increase the rent. Then the guardianship case starts, and they appointed our clinic as the guardian ad litem for her, and we went out as students interviewing her just like the guardian ad litem would do. And we find out that even though she has 2 bedrooms, she's sleeping on the floors. There's electrical wires and cords everywhere. It's a trip hazard. And so clearly somebody who needs a little bit of help. And then you try to narrowly tailor that kind of help, not the amount of help that they believed. And who gets to be appointed as a guardian? Not always the family. Sometimes it's either attorneys or other professionals that are appointed. My partner, for example, was appointed a guardian for a 96-year-old woman. And having to take care of her needs over the years. That's interesting kind of work, and not many people would want to be the guardian.
You don't have to go to law school to be a guardian,
That's
but you
right.
do have to take a certification course.
That's right. So after the judge appoints who the guardian is and says, okay, this person is clearly in need of some help, and they need to be protected, and we need to protect the environment that they live in, and so on. And we need to have somebody paying their bills. So that person needs a guardian. So the alleged incapacitated person is now an incapacitated person. And the judge rules that they need help with certain things. So now there's a guardian. Let's say Ethan was the guardian. What would he have to go through to once he's got that paper that says, okay, you have a judgment, now you can be appointed the guardian?
Okay, so he's received his commission, and if
You mean like a payment?
No, not like
so
a
commission
payment.
in a different way.
It's right. It's an appointment.
An appointment, okay.
And he has to file an initial report
Okay.
stating what he's arranged for his ward and how he's handled the finances. And then he needs to visit his ward at least 4 times a year.
Okay. Well, we would hope that
At least
it's
4
more.
times.
It's more times than
Right.
that.
Exactly.
Okay. But and he also has to get through some educational component to
Right.
know what to do.
Well, to get that commission, he needed to have taken a course
Okay.
and put the certificate in, submitted the certificate to the court. That's even before the order and the judgment gets signed.
Okay.
But also every May he has to file an annual report. And
Wait. So all of this stress and struggles, it doesn't just end when they become the guardian? It keeps
No.
going?
the court, you have to look over your shoulder all the time because the court is watching everything you do.
Right.
So now that the court is involved, they want to have a detailed accounting as to what's going on, where's the money going, what decisions are being made.
Yeah,
Correct.
absolutely. So there's the routine kind of decisions. I got to pay this bill and so on. Those get to be done, and then you file an accounting in the month of May for what did you do with that person's money over the last year. And so it's a detailed report and accounting, and typically there's attorneys that get involved in helping their clients do that. And then who does it get submitted to? It's the court examiner. So the court appoints another person who basically sits there and through the month of May looks through all of these different accountings and says, well, I trust that, or I don't, or they may have some additional questions. And then they go back to court, and you have a court date to either okay it or to say that there's a problem. Now, let's say that the person is now in a nursing home and they have a house and you're trying to sell that house. You got to go back to court and do a new petition to say, as the guardian, I want permission to have a broker appointed and I want to have the house appraised. And so the court will continue to be involved, and there will be court supervision through that whole process.
Every step of the way.
Up
Every
until that
step.
person is no longer deemed incapacitated, which usually is not the case, or until they pass, unfortunately, and then that money gets handed over to their estate.
But
Every
wait,
step.
then the guardian needs to file something else again.
It didn't stop when they became the guardian.
Yeah.
It didn't stop even after they're no longer the guardian. It keeps going.
A little bit. So there's a final report that the guardian has to file to say this is how things are going to be distributed. And with the court's blessing, then they get to distribute it. And then they're also entitled to a small fee for the work that they've done. So through that period of time. Now, all of that could have been avoided if the person had planned appropriately. So while you're healthy, you want to ensure that you have a good healthcare proxy in place so that you have the right person that you trust to make medical decisions for you in the event that you can. You want to talk to them about it. What is it that you want to have done? You want to have a good power of attorney, not the do-it-yourself document that you can download, because that may not have all of the provisions that you might need. You know, if I gave you the scalpel and I said, go ahead and do the surgery on yourself, that's not going to help to do a great job. You want to go to somebody who's skilled, who's had all the
Especially
years
if it's
of
the wrong
training.
scalpel.
Could be, yeah. You want the right tool for the right job, and you want to do it with the right person. And so having a professional who's helping you to do all of that, to guide you through and to better understand. You know, the saying goes, you don't know what you don't know. Sometimes you're not going to find out. It's going to be through a guardianship setting. And procrastination is not a good
You had
friend.
a client, when you had met with, I believe they came in, they were going to do a trust-based plan. They were thinking about it, and then it fell out of their mind, and they didn't end up moving forward. Do you remember what happened after that? They had come back about 6 months later, and they were asking us, okay, can we do the trust-based plan now? But at that point, the husband's health had deteriorated so quickly
Right.
that we weren't able to do a trust-based plan for them anymore. The only option was to do a guardianship proceeding.
Okay.
The problem is sometimes people say, let me think about it, and life happens, and different stressors come up, and as a result, people don't move forward until after it's too late already.
Well, they think they have time. But even if somebody has a power of attorney that hasn't been redone since 2020, I would recommend that they see to that too, because the form has changed and banks were refusing the prior form.
Wow.
Right. And so sometimes it's about advocating for them, and banks have not been friendly in that regard. But back to this, procrastination is really something that becomes an issue for a lot of people, and often you find yourself in a situation where it's after the fact.
Yeah, run out of time.
Right.
That family could have saved so much time and headache, and it's just very unfortunate.
Probably the biggest expense. People say, well, how expensive is it to have to go through this? The financial expense is one part of it, but there's also the emotional impact. Imagine that relative who's now in a nursing home, in a rehab facility. You're trying to help them to do things, but you don't have the authority to do that. And so now, instead of spending time moving quickly and helping them with things, you're spending time with attorneys dealing with legal issues of appointing a guardian. And so things become very slow in terms of helping that family member. And emotionally, I think that is a significant impact for that family. So helping them pave a clear path of what happens if I become sick, who's going to take care of things, what's going to happen, and they know my wishes, and it's all spelled out in legal documents that give them the tools later to go to somebody like Audrey and say, okay, we need to help mom or dad with things. That's important.
Yeah. Invariably, when we've finished doing an estate planning signing, lots of times clients are relieved. They have it in place and they feel secure.
It's one of the wonderful things about being an estate planner is you get to work with clients that afterwards you could see that the tension that they may have had in the beginning about things, that it's been relieved, and that they know that things are taken care of, and that they have a trusted attorney to help them and their family with things. That's a significant relationship that's very important. And you mentioned that in the beginning that you do also estate administration and trust administration. Can you touch a little more about what that means?
I deal with people's estates after they've passed. So I deal with their families. If they have a trust that they've done, we administer the trust according to the directions in the trust. And if they've done a will-based plan, I help with the probate. And if they have nothing, I do the administration.
Okay, so having a trust keeps it out of the probate court, and we call that surrogate court in New York. And then even if you have a will, you have to go through a probate?
Yeah.
Okay, what is that about?
It is actually the court verifying the validity of the will document that it's been executed according to the law. And
well, isn't a will self-proving? I mean, why do I need a judge to say that it's... I'm just being facetious. I'm just being a devil's advocate and asking probably questions that our audience might ask. Why doesn't a will become automatically valid?
No.
For some people, that is news. And so it's valid as a document when it's created, and if it's supervised by an attorney, there's a greater deference to that being valid. But you still have to go through the process of probating the will.
Yeah, invariably people come and say, well, I'm the executor of this estate. Well, you're only named the executor in the will. So
there's a difference between being the named executor and the executor?
Yes, the court has to appoint you.
Wow.
And
so they have the ultimate power.
They do. They issue a decree and letters testamentary that give the named executor authority as the executor to handle the decedent's assets.
Okay.
So
you mean if I'm named the executor, okay, in my imaginary siblings' will, and I'm named in there, and I go to the bank and I say, hey, Mr. Banker, I'm the named executor. Here's the will. Give me the money. So that I can do what the will directs me to do. They're not going to be able to do that. They're going to want letters testamentary.
Correct.
Letters testamentary.
Letters testamentary, and probably they'll want to see a death certificate too on top of that.
For sure. Okay.
But No, they definitely need letters testamentary.
And to do the letters testamentary, I need to probate the
We
will.
need to probate. And when you probate the will, it goes out into the public. Not that it gets publicized, but it's put into the records room and online even nowadays. You can search online on Web Surrogate to see what kind of estates have been filed.
Okay, interesting. So prying eyes could look at.
Anybody could see that. They don't even have to go to the court now. They can just sit down at their computer and do it.
From the comfort of their own home, they can pry into whatever estate they'd like to through the probate procedure.
Yeah, that's interesting. And so that process, I imagine, I know, but that process is not
Not speedy.
not a sweet and simple process
No.
either. Does it cost any money to do that?
Absolutely.
Okay, so there are filing
So
fees and
there's
things
a
like that.
Graduated filing fee schedule, and
Most estates that you work on, what's the filing fee?
$1,250 plus $6 for the certificate of letters testamentary.
Okay, and then there are attorney fees and other
Correct.
kinds of fees
Yes,
associated.
and there are executor commissions. We were talking about commissions.
Okay, more fees.
Right, absolutely, that are dictated by law.
Okay, interesting. So our practice, we work together, but in our practice, it's primarily focused on helping people stay out of court.
Yeah.
And so staying out of court through avoiding guardianship, staying out of court through avoiding probates. And people say, how do you do that?
Planning.
Okay, well, but that person that had a will also planned. But you're saying that when they have that will, it's going to need to be probated.
Yeah.
So planning in itself doesn't solve it. It's the type of planning that you do. And so oftentimes in our practice, we're planning with more comprehensive tools like revocable or irrevocable type of trusts that are helping to keep the assets out of the courts and away from those prying eyes and away from having that time toll.
Also, the continuity with the trust, it's so much easier.
And you're speaking from your experience as the person who administers trusts and administers probate estates and wills, and one is faster than the other one.
Oh, absolutely.
Okay.
Trust administration is definitely quicker and less expensive than probate.
Okay, so makes sense. Great. All right. Well, thank you for joining us for another episode of Davidov Wealth Podcast.
This was my pleasure.
Thank
Nice
you.
to have you on.